back to winning isn't easy. Is a diagnosis of interstitial cystitis sufficient to overcome a claims denial by Aetna? So I want you to remember that you, as the long-term disability policyholder or plan beneficiary, have the burden to prove your entitlement to benefits. You should be getting a copy of that policy or plan, reading it cover to cover so you understand what's the definition of disability, what's the definition of occupation, do I have to submit objective proof, and what is objective proof? One of the key things you need to understand right off the bat is that a diagnosis of interstitial cystitis is not going to be sufficient in and of itself. So let me tell you the story of a woman by the name of Boatwright versus Aetna. It's actually a Florida case from federal court. Mrs. Boatwright was diagnosed with interstitial cystitis with Hunter's ulcers, peripheral neuropathy, and she also had fibromyalgia. She applied for and was paid her own occupation long-term disability benefits by Aetna. But of course, what happens is generally after 2 years, the definition of disability changes from an inability to do one's own occupation to an inability to do any occupation. And in essence, you have to prove that you can't even do a sedentary type job. Now, in this particular case, the definition changed to own occupation, which was defined as any reasonable occupation test. Aetna obviously denied her claim based on the lack of current medical information from her physician and the results of 3 Aetna medical peer review doctors who looked at her medical records. And a vocational report was ultimately prepared that said she could do other work. And then they combined this with some surveillance. Now, you can understand that this case ends up in federal court. And Boatwright tried to overcome the lack of medical evidence by arguing that her diagnosis, that the lack of improvement over time, and the fact that there are no cures for either IC or fibromyalgia were sufficient to win the day. That didn't work. The federal judge disagreed, noting that diagnoses of conditions are insufficient to establish that you meet the definition of disability within the meaning of the terms of the policy or plan. Ultimately, the question before the plan administrator was whether or not the medical conditions precluded Boatwright from working in any reasonable occupation, and the denial was upheld. I think there's some really important lessons to be learned from this case that are applicable to not only IC cases, but all sorts of other cases involving ERISA disability carriers or plans. So what's lesson number 1? Lesson 1 is that a diagnosis alone is not sufficient. Number 2, that policyholder has the burden to provide medical information about their symptoms, how their symptoms impact their ability to work in any occupation or their own occupation. Number 3, restrictions and limitations based on those IC symptoms. For example, the frequency of the symptoms or the nature of the symptoms would require that they be close to a bathroom or that they have unscheduled breaks of, however long it takes for them to be in the restroom. Number 4, I think I've got my numbers here, right? The objective basis of the restrictions and limitations that impact that person's ability to work in any reasonable occupation. So you've got a diagnosis, you've got restrictions, but what's the objective basis of the restrictions and limitations? So you want to tie that back to studies that have been done. And there are some studies that will, track voiding and those kinds of issues. In this kinds of case, I particularly think that a functional capacity evaluation is appropriate. Well, why is that? A functional capacity evaluation does measure how long you can sit, stand, walk, stoop, bend, and lift. But most people who have IC will have symptoms while they're doing those types of activities, bending, lifting, picking things up, and potentially sitting. The FCE provider who is independent can document the frequency of any breaks that the person were in the restroom. And of course, what you want to do is to have your doctor endorse the evaluation test. If your doctor is not supportive of the claim, then you better well find a new doctor or with the assistance of your ERISA disability attorney, undergo your own independent medical examination by a physician who is not only sympathetic but understands IC claims and the nature of the functional restrictions and limitations. And of course, I think to tie it all together, you have to have a vocational evaluation that will rebut the carrier's position that you can work in a reasonable occupation. Many times I find that these carrier VEs have not taken into consideration the issues with sitting, the need to alternate sitting and standing, the need to use the restroom, the frequency with which a person uses the restroom, how that will interfere with a person's concentration or pace, how it would interfere with the ability to even attend work. So those are the kinds of things that I think should be developed in the course of winning an IC ERISA disability claim or filing a winning appeal. My appeals, for example, are 20 to 65 pages long, and that appeal is the trial of the case. You'll normally only have 180 days in which to file an appeal. And I just gave you a laundry list of things that need to be done, and you've got 180 days in which to do them. So it's really crucial that you understand the importance of what the policy says, your burden of proof, how the carrier arrived at this denial or termination, and work with an experienced ERISA IC disability attorney who can get you the disability benefits you deserve. Please don't let these kinds of mistakes doom your ERISA disability claim. If you have any questions about this, certainly feel free to give us a call because we do handle IC claims, and we also handle them in the context of Social Security claims. And as I've said before, these are not necessarily easy cases to win. It takes a team, in my view, to win these cases with lots of internal and external documentation to confirm that you are unable to perform your own or any occupation based on the terms of the policy. Got it? So if you've enjoyed this week's episode, please consider liking our page, leaving a review, sharing it with family or friends, and subscribe to this podcast. This way you'll be notified when the next episode comes out. Please tune in for another insightful episode of Winning Isn't Easy. Thanks.